thank you so much, and thanks everybody for hanging out this afternoon for a while to think about some of these important legal issues out there related to school technology, data privacy, and related concerns for us. We've got some, I think, important reminders out there to go over on some of these topics, and then some sort of hot off the presses issues to deal with some of the litigation going on out there in the world, both including some data privacy issues, some social media issues, and other school technology related concerns for us to think about. So we're going to cover quite the variety of issues today. Some of the things that I think are important reminders, I'm going to try and go through relatively quickly. Some of the things that I think are new and we want to spend some more time on, I'm going to do that. So I'll kind of adjust my pace as we go, walking through some things a little more quickly and spend a little more time on, I think, those newer updates that I think are important and deserve that time. And as Matt said, if you've got questions, please don't be afraid. I've got the Q&A box open. So as we go through, if you've got questions, as we're going to be kind of switching topics as we go, I'll try and address those as we can. And then we'll see if there are any follow-up questions at the end too. But I've structured this today as sort of a top 10 list to think about some of those top 10 issues that we need to be thinking about on this education technology front. And of course, the first few issues here relate to our ongoing concerns about data privacy, compliance with SOPPA, and those related things. And I think just that important reminder, number one, is to make sure that we are continuing to train and communicate with all of our employees about our responsibilities under SOPPA and data privacy. When we think about those basic goals that are in our statute, we've got to make sure we've got the right written policy, that we're putting in place those written agreements with operators, we're getting those things on the website. Those moving parts are out there that hopefully we've done and we continue to do. I know we did a lot of work at the beginning of its implementation back in 2021 to really focus on those policy and written agreement pieces. That continues as we go forward and we have new vendors and those sorts of things. But I think when it comes to training all staff, we've got to really focus on implementing those security measures. And we talk about those reasonable security practices. There is a component of that relates to training all of our employees, right? Who are using our devices, our networks, that are interacting with our network, so that we are implementing awareness of security, how to manage that appropriately, how to avoid unintentional data exposure, how do we identify and report incidents. There's really an important training component on that. And I think that this is a piece that we need to really focus on, because our system is only as safe as its weakest point. And, a lot of folks, I just spent the holidays with my parents, and I'm going to suggest that maybe their data privacy practices were not what I would have expected them to be, right? And so those are things that we want to think about for all of our employees, and how do we get them to a place where they're not downloading apps that are not approved onto district devices, that they're not, doing silly things like leaving their passwords on a Post-it note right on their desk for students and others to see, all of those things. That how are we, communicating with employees to make sure that we are being proactive in our data privacy approaches. And of course, the LTC has put together some great resources through the Student Privacy Alliance, and so certainly encouraging folks to use that as well. So again, making sure we're communicating with all employees about the responsibility to only use approved operators, that they're implementing those reasonable security practices, including away from school. If we're going to connect to the school's network from home remotely, how are we making sure that we're maintaining appropriate security practices that meet the obligations under SOPPA for us in that regard, and that we're following that policy. So that's a key first step, right? Is training everybody and that ongoing conversation about data privacy practices and getting everybody on the same page. The second piece to it that I think is just an important reminder that I want to make sure doesn't fall off the radar for us is that language that I think most districts have adopted in their press policies that create a data privacy officer and an EdTech committee as part of that. So just a reminder here, I presume most of the school districts here in Illinois who are paying attention today have adopted the press policies for SOPPA compliance. And when you look at the press policy and those procedures, it has some very specific requirements about who we are designated to approve agreements with operators and make decisions about that. And the default language says that it is the superintendent or designee who designates which employees have that ability to do so. And within the administrative procedure, it specifically requires the superintendent to specifically list those employees. So we want to make sure that we are meeting that obligation as part of our compliance. And as part of working through those reasonable security practices, getting everything in place, there's a role for an educational technology committee. And so just pay attention that if you've adopted the press policy, it says you shall have this committee who has some of these specified roles, like evaluating the use of online programs, saying whether or not they're approved, and developing that process for approval of new websites or applications or services that are not already approved. So, keep in mind, there's what we're doing and what our policy says, and I hope those line up, right? So please make sure that our practice is lining up with that for those step-by-step actions, what's in press. But I think as we move on, obviously SOPPA is a huge part of this, and we could spend a whole hour just unpacking some of those specific requirements of SOPPA, but it's not only SOPPA that have those requirements, right? We've got FERPA, we've got the Illinois School Student Records Act, we've got the Federal Online Privacy Protection Act, and all of those have components to it that we want to keep in mind. And I want to review some of those decisions specifically related to these other statutes where data privacy becomes an issue. And so we want to think about that certainly under FERPA and Israel, but also some FOIA issues, right? Some Freedom of Information Act issues that are important for us as well. So just to review a couple of these recent decisions, specifically by the Department of Education Student Privacy Policy Office, the SPPO. That's the federal agency that is tasked with implementing FERPA. And so a couple of their complaint decisions, here's one from 2020, just before the pandemic, where a parent has alleged a school district violated FERPA by disclosing records to a third party. And this was specifically a third party that was going to maintain information on behalf of the district. But here there was no violation because they said this was a third party engaged as an independent contractor of the school district, retained to perform an institutional function of the district. And so there was the ability to disclose under FERPA. Now we would know the next step of that, right, for us in Illinois is then to make sure that that third party vendor is an approved operator with appropriate data privacy protections compliant with SOPPA. We also just have to think about those less, techie, sort of more commonplace things like, oops, we sent it to the wrong person. Here's an SPPO decision where there was a violation of FERPA because records were sent, in this case, to a public work account of the parent rather than a private personal email account. So in this case, they sent some confidential information regarding the student to where the parent worked. And it was kind of a public account, sort of like, here's the email address for that company. And it was a small business. And they knew the parent worked there, and not the individual email account of the parent that the parent had preferred that they use. And that was clearly a violation there. This letter to Henderson actually came out of Illinois, where they found that the district violated FERPA by disclosing records by email without consent. And this is an issue where, oops, the school secretary had a clerical error that sent the email to the wrong person. And so we want to make sure that, when we're sending out records by emails, that it's going to the right people and only to the people that it's supposed to go to, and those types of considerations. So we want to keep that in mind when we're looking at that issue, so that we are maintaining that privacy of those records. I think the other half to this piece is the FOIA, the public records piece that gets outside of just the student privacy piece, but how we're maintaining records electronically. And I think that what's important is we have a number of court decisions over time in Illinois. This decision's now almost 10 years old out of Champaign, where the News Gazette was seeking the text messages on the personal accounts of, in this case, city council members who were discussing city business by text message. The city tried to argue, well, those are on our personal device, so they can't be subject to FOIA. The court said no. A message sent and received from a private account or private device is subject to FOIA if they are related to public business. And then a decision here a couple of years ago out of Chicago that held the same thing from another appellate district in Illinois. So I think it's pretty clear that, you know, we use our personal accounts for personal business, your school account for school business, and we don't mix the two. And then we shouldn't have a FOIA problem when we get a FOIA request for electronic records. And I don't think it matters so much the device we're using, as long as we're using the right avenue, right? If I'm using my personal phone to access my school email, one, we want to make sure I'm still using the reasonable security measures under SOPPA and what I'm connecting to and where I'm connecting to. I'm not on that free Starbucks Wi-Fi, right? And those kinds of things. But that, you know, for FOIA purposes, as long as we're using that district supported method, that's important. And I would really think twice about the texting. I think I would use email or some other supported method for that communication, because we might be creating records that are out there for us. The other FOIA issue that pops up is that redaction issue. Make sure that when we are electronically redacting documents that we are doing it appropriately. You know, here just a headline out of a case that where subject to a FOIA issue, you know, the Sun Sentinel FOIA'd the school district related to records for the Parkland school shooting shooter, and they provided redacted records, but they didn't do it correctly. So when they got the records, all the newspaper had to do was go and delete all the black boxes, and they could see the unredacted version because they didn't appropriately. So we just want to make sure that we are appropriately redacting those PDF files so that we get to where we need to be for us. You know, and also recognize that other types of media like photos and videos might be a student record, and we can think broadly about those types of things. But I think we'll kind of move forward for purposes of time there for us. A couple other reminders. Remember, we can't have a parent waive their rights to privacy as a condition of using one of our services, right? That's been pretty clear over time. And be careful about those social security numbers. There's very clear protections for that. So keep that in mind. But I think the other piece on the data privacy front that I want to talk about before we move on to some other topics is there might be other legal avenues to pursue these claims. And the case that I want to spend a couple minutes talking about here is a case just decided here in the Central District of Illinois just not too long ago. So a 2022 decision just from the past couple of months in HK&JC versus Google. Now, what is good for us who are on this call in this case is what you don't see is the school district part of the name of that case, right? So while this is certainly a school related case, the lawsuit here is against Google. It is not against the school district. But we could easily see how we could get wrapped into this pretty quickly, and we want to be very, very careful about that. So this case was a case brought by the parents of students related to the use of Chromebooks, alleging that it violates the Illinois Biometric Information Privacy Act because it was the Google through the Chromebooks was collecting, storing, and using biometric data of these school kids without the required informed consent of their parents. And in this case, the motion to dismiss was granted in part and denied in part. So there were several complaints, several counts in this lawsuit, and it was kind of a mixed bag, but ultimately, as we'll see here, the court is letting this case move forward against Google. And so just by way of giving you a little more information about the background of this case, these were all elementary and middle school students who were either in McDonough or Kane County, Illinois. That's where these families were from that filed this lawsuit. They were given Chromebooks that were pre-installed with the G Suite for Education. I'm going to guess that there are lots of you listening today that are like, we do that too, right? You know, their accounts were linked to their names and other personal details that we'd established in their account. And of course, there were features of the platform that required them to speak into the audio recording devices, look into their cameras. And in this case, again, remember, defendant here is Google. You know, as part of that, Google recorded their voices, imaged their faces, collected their biometric data for its database for use of the Chromebook. So the issue here, did that violate some of their other statutory rights? What the court acknowledges, sort of in the recitation of facts here, is that Google collected the plaintiff's biometric data and that was unbeknownst to the plaintiffs or their father or mother in that case, that neither of them had authorized, received disclosure from Google that it would collect, capture, or otherwise obtain their biometric data. And so the issue here is, where does this go? Now, Google argued that the Illinois Biometric Information Privacy Act were preempted by both federal COPPA and state law SOPPA, you say so, COPPA, SOPPA, whatever. But the court says, no, we're not going to dismiss it on that basis. We think that there is some uncertain interplay between the Biometric Protection Act and SOPPA. And so we're going to let this proceed and go on to discovery and potentially go on to trial on that basis. And I think that's really an interesting one that we're going to have to pay close attention to and watch. So this is not a final ruling on the merits of this case. This is simply failure to dismiss, which means the court says we think there's a potential valid claim here, right? That it gets past that motion to dismiss stage and can move on beyond that. So I think this is one to pay close attention to, because I'm going to guess many of us, maybe most of us here, our districts are using those same programs and platforms. And so obviously this is a piece that's going to be concerning. And I think obviously if Google loses this case in the end, there's probably gonna be some changes in the process that we're going through. So I just want to make sure that we're all on the same page and paying close attention to what moves forward there. But we now have our first reported case where SOPPA is an issue. And interestingly enough, it's not the school being sued, it's the vendor, it's Google. So we want to make sure that we're doing our part not to get in trouble with that. But I think that is an interesting one, and one we're going to be paying close attention to, right, as this case moves forward. So let's, and of course, if you guys have questions about that, feel free to put in the Q&A and we'll come back and talk those through. But I want to talk through a few other issues here. Next piece of it is we got a lot of data that we are collecting in different ways. And we want to make sure that we're being accountable to that. And I think that, you know, it's really hard to effectively monitor the use of those one-to-one devices that we have that we're, you know, school kids are taking home, or they're using them on other networks. You know, that's really hard. And a lot of us are using systems like Gaggle or a Bark system or other things like that I know we use, where we've got a lot of data. And then what are we doing with it, right? So if we've got students who are expressing self-harm, bullying, violence at others, other inappropriate contact or content, sexualized content, you know, how are we monitoring that? And then what are we doing with that information, right? And I think that there's a careful balancing act that we need to be thinking about here. You know, if we overreact, we might violate students' rights. We might, you know, be pushing the boundaries of the Fourth Amendment, to First Amendment free speech. We might be creating a culture where students aren't free to use our devices and technology in all the ways they might need to meet all of our educational goals and expectations for them. But when we underreact, we may have liability, right? Where we're not being responsive to known instances of bullying or harassment or child pornography or violence, and not having control over the culture that might be developing in that situation. And so finding that balance is really important. I want to make sure that we are being active participants in knowing what data do we have and how are we monitoring it, how are we not monitoring it, and what are the pros and cons of that, and what are some other districts doing and what's working for them. And I think that's got to be a really important point of conversation that we are really thinking about. Number 6, continuing to push to make sure that we are using programs and services that meet the accessibility requirements for students with disabilities. We know that we have those requirements embedded not only in state law and have had for a couple of years now, but as well as it being a long time expectation in federal law, that we want to make sure that our applications and services that we're using are meeting those accessibility requirements. And I know that has been a frequent concern of mine as somebody who spends a lot of time in the special ed world. Particularly during and post pandemic, a lot of districts have significantly expanded the use of an online curriculum or similar types of programs, either as an alternative or as part of the regular school curriculum. And as part of that, a lot of districts have used a lot of third-party vendors to accomplish that. And what I've come to realize is, those vendors will all, as part of their sales job, tell you, yes, we are meeting all of those privacy or accessibility requirements, right, of the law. But in reality, when we're sitting down, we've got a student with a visual impairment or a hearing impairment or other concern, do they really? And that's a major concern, right? So we want to make sure that as we are vetting our different options for vendors, that is something that we are actively thinking about. Okay, so let's shift gears now into thinking about some social media cases. If you've listened to me before, you've heard me talk about the Supreme Court's decision in 2021 in the Mahanoy case, really looking at when and how school districts can discipline and regulate student social media use. And we've had several cases since that time that I think have really helped to bring some more concrete understanding to the Supreme Court's decision in Mahanoy. And so I want to talk about a couple of those cases today. One that was just decided within the last week or so, that I think is really important for us to think about what that means for us as we look at what we do with this off-campus social media piece and where the limits are for us. And I want to think about in a couple of contexts. But just quickly, if you don't remember the Supreme Court decision, this case involved a student who, when she did not make the varsity cheerleading team, she went to Snapchat and expressed her frustration with that and posted some obscene language and other things, foul language. Maybe obscene is maybe too much of a legal standard here because it was found to be protected speech. So not an obscenity, but foul language here at Snapchat. She was then kicked off the team and the JV team that she was on, and sued, and the Supreme Court held 8-1 that the district's action did violate her rights under the First Amendment. However, they said, we do think that there are times when it might be appropriate for a school district to be able to regulate some off-campus social media speech or some off-campus speech. This case was not one of them, but they did articulate some scenarios, and they articulated exactly 4 situations where they feel like the First Amendment would permit schools to regulate or potentially impose discipline for the off-campus speech and electronic speech of a student. And really what I think we see in the court decisions since this time is that courts are saying, this means there are 4, and these are the 4, right? serious or severe bullying or harassment targeting particular individuals. 2, threats aimed at teachers or other students. 3, the failure to follow rules concerning remote or online school activities. And 4, cybersecurity breaches. Right? So those are the 4. The 2 that have been litigated most often in the dozen or so cases that we've seen in the last couple of years in the federal courts on this issue are the first 2. When is bullying or harassment targeting individuals enough, serious or severe enough to allow the school to impose discipline? And how about those threat cases? I want to talk about a case that falls in each of those categories, right? A threat case and then a harassment case, to think about what that means for us, and just as an example of how that's being litigated. So let's talk about a threat case first. This case comes out of Manheim Township, Pennsylvania. And this is a Snapchat case where a student sends a video meme and some other messages to another student. So this is not a situation where we're talking about a post that was shared publicly by this student or with a number of students, but really this was a one-on-one conversation between the plaintiff here, JS, and student 1. And JS and student 1 are having this Snapchat conversation or back and forth in which they are talking about student 2, who is not a part of the conversation. And they created a meme in which they suggested that student 2 might be a potential school shooter, and created a meme with a picture of student 2 saying, "I'm shooting up the school this week," etc. And so JS, eventually the school finds out about this through a variety of means, but the school expels JS, who sent this meme to student 1, under its terrorism and bullying policies both. But here the court reversed it, saying that because this was not a true threat and did not cause substantial disruption to school, the student could not be disciplined for it. Now, what we see here is that the court says, while the actual words employed in the memes, read in isolation, plainly suggest a school shooting and violence, the means viewed in toto did not threaten student 1 or anyone else, but offered only the plaintiff's opinion that student 2 was a potential school shooter due to his penchant for the music of the band Cannibal Corpse. If you're not a Cannibal Corpse fan, you can see their album cover here, and can see why the court was such a fan, right? But the court says that while the post was mean-spirited, sophomoric, inartful, misguided, and crude, it was not intended to be a threat, and that when you put it in context, it was not a threat, and compare this to other cases saying this is not a direct threat of violence. The school said, okay, well, even if it's not a direct threat that would put us within that exception that the Supreme Court articulated in Mahanoy, don't we still have Tinker and the substantial disruption? And don't we have a long line of cases that say that when a student makes a post that could reasonably be interpreted to be a threat, even if it wasn't intended to be a threat, isn't that materially disruptive? And can't we use the Tinker material substantial disruption standard to do that? And the court here said, possibly, but in this case, in these facts, that Snapchat post sent from one student to one other student, right? All JS did, all the plaintiff here did was send it to one other student. They said that did not create a material disruption. And in fact, the court went so far as to say that it was the school district that created the disruption when it sent out an email to parents saying that it had received a threat of violence against the school district. So, and we've got a couple cases that have kind of held similarly in that regard. So kind of an interesting line to walk. I mean, as the Ninth Circuit said many years ago, these cases are kind of like tightrope balancing for school administrators. And I do think this is a tough call. But here they said, once they had conducted the, threat assessment, looked at the post in context and realized that this was not a threat, but was simply making fun of another student. Now, maybe we could get into that harassment targeting an individual standard, but that wasn't how the school argued this case. They argued this as a threat only, and the court said no. So I think that's really an interesting one. The other case that I think we've got to pay attention to here, and maybe this is a case that itself could be headed for the Supreme Court, is a decision by the Ninth Circuit just last week. So this decision was issued on December 27th, which, as I look at my calendar, I think was last Tuesday, right? So we're talking about that being less than 10 days old, this decision. And this is an appeal from a lower court decision. So you can see that this has been going on since 2016. So this is an issue that first happened back in 2016. It's taken till now to get the Ninth Circuit decision on this. But here, the Ninth Circuit finds in favor of the school, saying that this, harassment of others was certainly within the school's realm and within the boundaries of Mahanoy to be able to provide discipline. So there are a couple students here on the appeal. There were a number of students involved in the lower court decision, but on appeal, we're really talking about two students, one named Epple and the other named Chen, their last names. Epple is a student who created a private Instagram account where he could share funny memes, images, and comments with his close friends that he didn't think other people would be appropriate. And he only allowed about 13 of his friends to follow the private account. And Chen was one of the followers who did engage with some of the content by posting comments or likes to the Instagram account. And there were times in this post that Epple would post cruel things, sometimes making fun of a student's braces or weight, but other things that were clearly racist and very specific to Black classmates, referencing things like slavery, lynchings, guerrillas, using the N-word, things that were clearly racist and had racist tinges to them. And even though it was a private account, of course, the contents leaked to other students and people were upset, and the public reaction was very negative. There were protests at school. It became a very big deal for the school district. But the court here kind of goes through a two-step process and said, first of all, is this speech that the school could have regulated or disciplined for if it had been made on campus? And the court says yes, easily. If someone used the N-word or used these languages in reference to other students on campus, clearly it would not be protected speech, but would be something that the school could regulate if it had been done or said on campus. So then the question is, so because this took place off campus, allegedly, is there a sufficient nexus for the student to justify discipline? And the court says yes. Given the ease with which electronic communications may be copied or shown to other persons, it was plainly foreseeable that the post would ultimately hit their targets, with resulting significant impacts to those individual students and to the school as a whole. And while the student emphasized he did not intend for these people to ever see them, the court said, but having constructed, so to speak, a ticking bomb of vicious targeted abuse that could be readily detonated by anyone following the account, he can hardly be surprised that his school did not look the other way when that shrapnel began to hit its targets at the school. Very, very direct language there from the Court of Appeals related to those posts. So really, really interesting. And so they find here that the school had a role in protecting other students from being mistreated by their classmates, and a failure to respond to the harassment could have exposed it to liability on the theory that it failed to respond adequately to a racially hostile environment once it became aware. And the court said, students such as Epple remain free to express offensive and unpopular viewpoints, but that does not include a license to disseminate severely harassing invective targeted at particular classmates in a manner that is readily and foreseeable transmissible to those students, and therefore the school could, under the Mahanoy approach, discipline and affirm for the school. Now, the other part of this decision is, but what about Mr. Chen, who wasn't the one who made the posts, but simply commented on a few, liked a few, right? And so he said, the court said he affirmatively liked 2 posts that were clearly racially harassing and denounced in multiple terms another follower who had criticized the post. So he was at least akin to a student who eggs on a bully who torments classmates. and a school may properly take account of such affirmative participation in what ended up as abusive harassment targeted at particular students. And many students said that the severity of the hostile environment was there because they knew that other students had participated and liked the posts. So really an interesting decision here. Even the student who merely liked and commented on the posts was enough for this court, for the Ninth Circuit Court of Appeals, to say, hey, we think this is something that is within the school's ability to regulate. There's actually an interesting concurring opinion here that also talks about, that goes so far as to say that we think that in the school setting, the school should have the ability to prohibit any sort of hate speech, and they use that term hate speech. But I think that is an important one to pay attention to when it comes to where student social media goes, and will be interesting to see if these students try to appeal this now to the Supreme Court, and whether the court would even take it in light of the relatively recent decision in Mahanoy. I don't know that this creates any sort of circuit split yet at this point. If we were to get a circuit split in the future, maybe that's when the court would take it up. A couple other points here to round out our topics. We've got to also think about students' other constitutional rights, not just the First Amendment rights that we see, through Mahanoy, but certainly those Fourth Amendment rights. When we're talking about, being able to search a student's device and those types of things. Remember that standard for us is reasonable suspicion, but that search is both justified at its inception and reasonable in scope. And we've got a number of cases over time where school districts have been found to violate students' rights by digging too far into their accounts. I do want to just remind us of a couple quick things here. Remember, the school code specifically prohibits us from requiring a student to give us their password or other information to gain access to their account on a social networking website or to their personal email or those types of things in order to investigate. We want to be careful here. Now, we can have some reasonable suspicion cases. We've got a relatively recent Illinois case here that says, hey, the school can look at the phone if they've got reasonable suspicion. In this case, there had been a violent meme posted, and they were looking to see if the student had it on their phone, if they're the ones who had posted it by having it in their camera roll. And here they said that this search was reasonable in scope and had justified cause at its inception. But I'm so nervous about the idea of looking at what's in a student's camera roll, right? Even if we have reasonable suspicions, should we be searching? Just think about this decision here, a couple, weeks ago, where this case is going on, where you've got a Colorado principal who's being prosecuted for possession of child pornography after, as part of his investigation of a student sexting case, had downloaded those images to save them. So we just want to be, I think we want to be overly cautious about when it's time to get law enforcement involved instead of our own, trying to do our own investigation there. There's a line to be drawn, and I'm nervous about that, and I want to make sure that we're paying close attention to that. A question that was here in the chat, the reasonable suspicion standard applies only to personal accounts, not to school issued accounts. And I would generally agree with that, right? When we're talking about our own school account or device that we've, under our acceptable use policy, there's generally not an expectation of privacy there. That's made clear in our policy language. When a parent or student is signing off on that acceptable use agreement, we own that account. And I think that some of the court decisions related to that, even on the employee side, would make that clear. I think it's when we're talking about their personal device and their personal accounts where we want to make, we understand that we've got those concerns. So important clarifying question. So thanks for that. Number 9, as we walk through our top 10 list, relates to our own district operated social media. I suspect that many of you in your role get the privilege of also getting a part of the obligation or responsibility or the fun of helping to manage the school district's own social media accounts. And we've got to remember that there are also some legal issues related to that. And first of all, I think it's important to recognize that we've got to be careful about using a a personal account for school purposes or a school account for personal purposes, right? We get into some interesting issues there, and we want to make sure that, that's true. You know, sometimes we'll see somebody create like an official account for the school basketball team, you know, maybe the coach does, but then they also are kind of using it as their personal account too. We've got to be cautious about that and make sure we're not doing that. We've got a couple decisions over time, again, reminding us that when we create an account, that might be, and we're using it for official government purposes, that there may be First Amendment implications there in terms of not being able to block people under the First Amendment and not being able to moderate content. The Second Circuit case dealt with the former president's Twitter account, which I guess now exists again. Because he also used that account for official government purposes as president, he couldn't, limit comments and those sorts of things to that. While that standard applies to us as school officials as well, I think the more interesting case here is the recent federal decision out of Wisconsin in the Krasno case, which involved, now in this case, is a university case, but again, the same standard would apply to us. So this case specifically involves the university's Instagram and Facebook accounts, right? So University of Wisconsin-Madison has, as all universities do, an Instagram account and a Facebook account. And the plaintiff here was a former student who describes herself as an advocate for the humane treatment of animals. And something that she frequently did was to leave comments on the university's Instagram and Facebook pages, expressing her opposition for the university's use of primates in its research. And then she found out the university had been deleting her comments or hiding them from public view. And then she filed this First Amendment lawsuit seeking damages under Section 1983. And so the court here did, in this recent decision, grant summary judgment to the university. But I do think there's some important lessons here. So don't just say, oh, the university won this case, I don't have to worry about it. There's some very specific things here that I think allowed the university to succeed in this litigation, to show that the First Amendment was not violated. And so the key to all of this is that the university had a policy, a very specific policy that outlined when and how it could moderate, and specifically at issue, off-topic comments in a way that was reasonable and viewpoint neutral. So under the university policy, if someone posted an off-topic comment, the university would be able to regulate that, delete the comment, hide the comment if it was off topic. And what was happening here is that this former student, Krasno, was posting, like maybe they posted a picture of, the football game, or just a picture welcoming freshmen to campus. And, she would post something on there about, the animal research, and they would hide. And they said, because it was off topic, and because the university actually applied it in a neutral way, so that they actually monitored and reviewed other off-topic comments, the court here held that the student had no First Amendment right to post on the university's social media pages unless they were germane to the topic of the university's post. Right? The policy says that the university has the right to remove content that is off-topic, obscene, a violation of intellectual property rights or privacy laws, commercial, or otherwise illegal, or not germane to the subject matter of the institution's post. And the court said that policy was legal, and that its implementation of it passed First Amendment muster. Now, I think that this is one that could easily go either way if the policy language wasn't good or if it wasn't consistently applied. So university wins this case, important lessons for all of us in that case. But also remember some other things. We've got some FOIA issues here. We've got some PAC opinions under FOIA saying hey, there was a FOIA saying we want a list of all people or users that have been blocked from in this case, the village's social media accounts. The PAC found that that was subject to FOIA and had to be disclosed. So we want to be very careful of making sure that we are not going too far in terms of our regulation of comments. And I think if we are, do we have a good policy, and how we alert the public to those expectations for that? I think that is important for us to keep in mind. And then my number 10 here is make sure that when we are using, and our employees are using the school's network and email and our other systems, that we're doing so in a professional manner. And so I've created a top 10 list within my top 10 list here for tips on using your school email, so that we are being very, very cautious to make sure that we are not creating that bad email reputation, right? Whenever I talk to school staff, I always say, dance like no one is watching, email like it may one day be read aloud in a deposition, right? Because those emails can come back on a FOIA request or a student records request. We make sure we're not putting things in writing that aren't there for us. And that includes not just emails, but Google chats or text messages or other things that might be related to students or the school business, and thinking bad about that. So let's think about that professionalism. First of all, remember, it is not an inherently private form of communication. So it may be subject to FOIA, it might be FOIA'd, it might be forwarded by someone, right? Think about that student. He said, hey, I created this private Instagram account, so my expectation was nobody else would see it. And the court's like, no, all it takes is one screenshot or one forward or whatever else. So think about where that might be shared. We want to maintain that professional persona. So we want to try and create friendly, polite, grammatically correct messages, right? Remember, in email, our nonverbal cues are not going to be there. So sarcasm and emojis and other things are not going to always translate like we want them to, and may not be that professional persona that we want. We also want to make sure that our emails are purposeful and not too long, and that the subject line matters. You know, no subject emails or emails that aren't telling us what it's about are not helpful. And we want to make sure that if you want people to read your emails and then to have the impact they have, that we have an informative and specific subject line, and then it starts with a call to action. And what is the best way to get human beings to pay attention? Use the word you, because we are all inherently narcissists and we like to think about ourselves first. So when we start with that, it helps. Email is a great way to reinforce those in-person conversations, to follow up, to make sure that we've documented something that happened. And so really that's an important use of our email. And it is not intended to be a forum to express displeasure, right? We want to make sure that emails are positive and solution-oriented, right? And that we're not spending time using our school's email system for those types of complaints. That's not the purpose behind it. If you send too many emails, people will just stop reading them, right? So make sure that your emails are for a purpose and for a point. You know, the meme I see frequently is like, here's another meeting that could have been an email. Well, true, but that requires people to read the email and understand it. So we want to make sure that we are clearly getting there. It's important to acknowledge emails, especially important ones, so that people know that you received it. I think that that's true. I see that particularly with schools and parents who are complaining. Maybe it's going to take us a day or two to get a response together to their email or to understand it, but to let them know you've received it and are working on it can be an important way to lower the temperature and set us on the right path to solving the problem. And also just think about basic courtesy, right? What are you going to put in writing? And also sometimes we got to have a face-to-face conversation. Don't create those records. Don't vent in email or in GChat or those types of things, right? And you know, when you're sitting next to somebody, don't just send them an email. Have a conversation. Be a human with them sometimes. We love tech, but tech shouldn't replace those human relationships and basic courtesy. We've all been guilty of the reply all mistake. But be careful about that before you hit reply all, and really think about it. One of the things that I've taken to doing myself is, for any sort of substantive email, I sort of draft it not in my email. I open a Word document, write it, read it, spell check it, and copy and paste it over. So that way it gives me just one more step to make sure that I'm not going to make a mistake by hitting send too early. As an attorney, the word not and the word now mean very different things. You should not do this and you should now do this mean something different. Do I have that typo in there, right? That's important. And then again, keep those personal emails personal, work emails for work. We don't want a lot of personal content on your work email, and really think about, how we are using our personal email for those purposes. I see too many school employees that use their school email for everything, their Amazon account and their everything else, right? No, personal for personal, work for work. We're not going to mix the two. So, I think some bottom line things here to take away as we end: make sure that employees, students, and parents know and understand our policies, our acceptable use policy, our data privacy policy, our expectations for social media. Make sure that's clear. Educate employees on those privacy and data protection issues. That's got to be an ongoing training. It's not a one-time thing. That's an all-the-time conversation. Let's intentionally use our technology to make real connections, because if we have a void, the trolls are going to fill it, right? So let's make those real connections and be good examples of that, right? I think that a lot of us in the roles that we're in, I see what everybody's role is in the chat, right? We can be good stewards and be good models of that and lead by example. And I think that's particularly important for us to think about. So those are my top 10 things that I wanted to make sure that we're talking through today. I think there's some interesting moving parts out there, especially when it comes to those new social media cases. I think that Google case, federal case involving the Biometric Information Privacy Act, is really interesting to see where that goes against Google. I think we just have to continue to meet those ongoing obligations with SOPPA and make sure employees understand that, not only when they're at school, but when they're accessing the school's network from any location. So before we wrap up today, if there's any questions, anything else we want to talk through, now is the time, so that we can go into 2023 strong and see what else the legislature has to bring us this spring, or what the courts have to bring us throughout the year.